Well, hello, everyone. My name is Pat Parody, and I'm the Executive Director of the Center for Constitutional Studies in the Faculty of Law at the University of Alberta. And I'm joined today by Professor Carissima Mathen. We're very pleased that she could join us because we know that this is an extremely busy time for academics beginning of term. So as this is a webinar and most of you are watching from elsewhere, I encourage you to reflect on the land that you inhabit, as I acknowledge that the Center for Constitutional Studies is located on Treaty 6 territory. We acknowledge and honor the ancestors, the traditions, the spirit that first drew Indigenous people, the Cree, the Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Inuit, Saulteaux, and then settlers to this place. In acknowledging this territory, we also recognize that the ongoing acts of settlement and colonization that took place and continue to take place here. We are grateful for the many benefits we've received as a result of treaty, and we know that this land acknowledgement is only a very small step in its recognition. But we trust the spirit and intent of the treaty to sustain us all in a stronger and lasting relationship. Now, before I introduce Professor Mathen, I'd just like to note that this session is being recorded and it will be available on our website in a couple of days. And you do not have to have registered, by the way, to get access to the recording. You will not be able to use the chat function during the webinar, but if you want to ask questions, just use the Q&A button at the bottom of your screen, and it will give you the option of remaining anonymous if you choose to do so. Now, lastly, there will be a feedback form that will be provided to you after the webinar, and we would very much appreciate it if you could provide us with any feedback you have. So now we've heard a great deal about vaccine passports and mandates in the last number of months, whether they are legal. People are asking, are they constitutional? Can the government really do this? Among other things, concerns have been raised about the measures and whether or not they are a violation of the rights protected in the Charter of Rights and Freedoms. And of course, because we are the Center for Constitutional Studies, what we're going to be talking about today is whether or not those vaccine mandates, passports are in fact constitutional. So just by way of a bit of an agenda, what we're going to do is begin by defining what we mean by passports, mandates, restriction exemption programs, immunization records, that sort of thing, and then talk about what the Charter actually applies to, then go through some of the rights and freedoms that may be breached by some of these measures that the government is imposing, and then lastly talk about what the government can do to justify its actions and whether or not those would be acceptable by a court. So let me introduce our speaker now. Professor Mathen has been a professor in the Faculty of Law at the University of Ottawa for the past 11 years. She holds, I should say 10 years. She holds an LLB from Osgoode Hall Law School and an LLM from Columbia University. And prior to joining the University of Ottawa, she was a faculty member at the University of New Brunswick, after serving as counsel and later director of litigation for the Women's Legal Education and Action Fund. And as director of litigation for the Women's Legal Education and Action Fund, she was involved in a number of formative charter cases before the Supreme Court of Canada. And that was the 90s, which was a very, very interesting, a fractious time in the Charter's history. Her primary expertise is Canadian constitutional law, and she's published numerous works in the area. For example, her book, Courts Without Cases, The Law and Politics of Advisory Opinions, was published in April 2019. Her latest book, published in 2020, is The 10th Justice, Judicial Appointments, Marc Nadon, and the Supreme Court Act Reference. She's just recently been appointed the new editor of Canadian Constitutional Law, 6th edition, which is a very popular casebook in law. Now, Professor Mathen has also published numerous op-eds and is regularly cited in national media. In 2018, the University of Ottawa honored her longstanding commitment in public discourse with its Media Relations Award. And she was also the recipient of the Law Society Medal in 2018, which is one of the highest orders bestowed by the Ontario Bar Association. So welcome, Professor Mathen, and thank you again for joining us. I know this is a very, very busy time. So what we're going to be doing today is I'm going to be asking questions and Carissima is going to be answering them. I'm going to refer to her as Carissima because we've known each other for almost 30 years. So there you go. So let's begin then I'm going to ask if you would please just let's set the stage by way of definitions. What do we mean by vaccine mandates, vaccine passports, restriction exemption programs, and immunization records? Can you tell us the difference between them?
Sure thing, Pat. Thanks for reminding me of the passage of time. It's great to be here, and welcome to everyone. So, of course, those terms will depend on a lot of different factors, and they are much in vogue. I personally don't find the term passport that helpful because I think it's become quite loaded, and it's not necessarily helpful in a descriptive sense. I mean, we think of passports really around travel, international travel, sovereign territory, and so forth. And I think within the domestic context, where you're really talking about entry into certain spaces where the government or indeed a private enterprise determines that there's a particular risk of the transmission of a serious public health of a disease, then I think it's more accurate to speak about vaccine certification or proof of vaccination to gain access to particular spaces. So I think that would be a program where indeed there are conditions for entry, and we could think about that as proof of vaccination or certification. If we're talking about a vaccine mandate, again, while there's no definitive legal definition for all contexts, that seems to me to suggest more of the state actually requiring everyone to be vaccinated. So mandatory vaccination for everyone, which has not been discussed at all in Canada. And in fact, very few places around the world where that's being discussed, where the state would literally force you to get vaccinated. We do have some examples from decades and centuries past, and indeed there is a very famous United States decision from 1905 where a municipal mandate requiring vaccination was upheld as consistent with the United States Constitution. But nobody in Canada is talking about that. We're talking about, again, demonstrating that you have been vaccinated to gain access to certain spaces. Now, my understanding around the term restriction exemption, as it was introduced by the Alberta government this week, is that it's essentially that kind of system, but for whatever reason, they've opted to use a different term to discuss what it is that they want to have happen.
And what about just immunization records?
Well, immunization records, of course, would be a record of every immunization that a person has had. And that's something that, of course, people would want to have collected and kept somewhere so they can keep track of them. There are, I believe, certain immunizations that need to be renewed every so often. And that's something I think that we've had with us for a very long time in Canada. And certainly you often have to look at that if you're traveling to particular countries where there might be certain other diseases or health risks in place. And so an immunization record, I think, could obviously be part of the way that proof of vaccination is effected within a particular jurisdiction.
Thank you. All right, now let's move right into the charter. Can you tell us when the charter applies and when it does not? Because that's what we're going to be talking about today, is the charter.
Absolutely. So, and this is a really important question because the Canadian Charter of Rights, being part of our Constitution, is primarily a document that puts certain burdens, puts certain limits on the state in how it deals with citizens, how it deals with individuals within a given society. And so the Charter of Rights and Freedoms applies to the state. So you are guaranteed protection for your various rights and freedoms as against the state, whether that be laws passed by the state or actions taken by state agents, for example, police officers, but any sort of policy that's developed by the government under the authority of a law, for example, under a health act. You might have the Minister of Health enact certain restrictions. Those definitely have to be consistent with the charter. So, and we've seen some challenges to some of the restrictions taken by various provinces. The Atlantic bubble, to the extent that it prevented people from entering provinces at all, that was subject to charter challenge because it was a policy enacted by a province, by government, that it was alleged to violate people's rights. So we hold charter rights as against the state. We don't hold charter rights as against private actors, whether those be businesses or individuals. We can't sort of claim a charter right as against anyone other than state actors or as against laws that are passed by the legislature.
Great, thank you. That's often a point of confusion that people have. And so we have the charter and we also have human rights laws, which are a different kettle of fish entirely. So we're going to be talking primarily today about the charter. Thank you. Thank you for clarifying that. So now let us get into specific sections of the charter. And so, for those of you who don't know the charter, it's part 1 of the Constitution. It's part of the Constitution. It's the first 34 sections. And we're going to go right into section 2. We'll be talking about section 1, which is the section that allows the government to justify what it's doing at the end of this section. But right now, let's get into section 2A and ask about freedom of conscience. So how do you think freedom of conscience fits in here?
It's a great question, and you're absolutely right. The charter is divided into various sections that relate to different kinds of rights and freedoms. And the very first substantive section, if you will, is section 2, which is called the fundamental freedoms. And the first one is freedom of conscience in section 2A, followed closely in the same section by religion, but we'll get to that. So freedom of conscience is a really interesting fundamental freedom. Obviously, we can think of it as being very important. It hasn't been the subject of a lot of case law in Canada. Most of the case law in relation to the fundamental freedom in section 2A has focused on religion. So we don't yet, I think, have a great idea of how a court would approach this kind of claim, but we can extrapolate from how the court has dealt with other kinds of charter claims. So I think that freedom of conscience is clearly something that would inhere in an individual belief that is very important to that person. So it would have to be a sincere belief that for that person presents a barrier from achieving or abiding by the condition, in this case, a condition to get a vaccine, to have access to a particular place. So the sincerity of the belief is something that would have to be accepted by the court. That's usually not a high bar, but it is something that can be used to deny the claim. And then what does the belief have to be about? And here it seems to me, if we kind of look at how the court has treated, religious belief, I think it has to be a belief that relates to something extremely important to that person, and something where they believe it would be deeply wrong to have to do whatever it is the state is requiring them to do in order to gain access to a particular benefit. So the belief regarding the vaccine, I think, can't be trivial. It can't just be one where the person believes it's an inconvenience. I think it has to be, the person has to be able to show that the belief is one that's really essential to, in effect, how they think about the world and their place in it. And the couple of cases that we have had where courts have dealt with freedom of conscience and have accepted that there's been a particular claim has been in the prison context, where an inmate has a belief, for example, that they have to follow a vegetarian diet. They believe it's deeply wrong to consume meat. And in that case, you can see where they really have no choice about what's being served to them. Courts have acknowledged that that is the kind of situation where a person could have their freedom of conscience potentially infringed.
Okay, thank you. Well, it's a tough one because, as you say, there isn't a lot of case law on freedom of conscience. Now let's go to freedom of religion. It's in the same section, 2A. What about
Sure.
someone?
So freedom of religion has a long tradition in Canada, even before the Charter of Rights was entrenched in our Constitution in 1982. Certainly, there were cases that talked about freedom of religion. The Canadian Bill of Rights, which was a non-constitutional, but still an important federal law that was passed in 1960, protected freedom of religion. That has shifted, from one era to the next, but for a number of decades now, the Supreme Court of Canada has said that freedom of religion protects your right both to hold certain beliefs and to manifest those beliefs in your behavior. And it protects you against a coercion by the state that would put pressure on you to act in a way that violates your beliefs. It's very individualistic. So it's very much based on the sincere belief of the person that doing something or refraining from doing something, let's say accepting some kind of medical treatment, would conflict with a profound belief that is really important to your religious identity. And there's language that the court uses to say it has to be something that where you believe a particular course of action is necessary. This is the language the court uses to further your relationship with the divine, because of course there has to be that it has to be some belief that makes it religious in nature and not just any other kind of belief. So they talk about the idea that there's some kind of relationship you have with a divine being or some kind of sense of the divine. So interestingly, while the existence of religious traditions in, let's say, the major Abrahamic religions, or you can look to religious texts or a religious leader, an official, that kind of evidence can be admitted by the person to show that, well, this is why I happen to have this belief. If you look at the second commandment, for example, I really want to live my life according to that particular dictate. It's not determinative. So the fact that you are claiming something as your religious belief and it doesn't happen to accord or be consistent with any readily identifiable religious group, that's not an automatic it's not an automatic fail for your argument. So it is quite individualistic. The court has taken that view because it says that it doesn't want to get into the area of having to adjudicate religious dogma and having to pick and choose among what is a valid religious belief and what is not. It doesn't think that's an appropriate place for a secular court to go. So it's very much focused on the individual. It has to be sincere. Also, whatever it is that you're alleging interferes with that belief, it has to be more than trivial. Now, that could potentially be an issue when you're talking about the effect of a vaccination certification on your religious belief, but you would have to be fairly precise in articulating what is the nature of your religious belief that prevents you from accepting the vaccine as a condition to have entry into a particular place.
Okay, thank you. That freedom of religion is a tricky area because the court, of course, doesn't want to get into the business of deciding which religions are legitimate, which are not, etc. As you say, it really depends on the individual's sincere belief, and the infringement has to be non-trivial. Okay, well, let us jump then from the fundamental freedoms, of which there are several, but we're going to jump to Section 7 because it's a big one in people's minds, and you hear a lot of arguments in this regard. So Section 7 protects the life, liberty, and security of the person in accordance with the principles of fundamental justice. And so you've got life, liberty and security of the person. So people are making arguments such as if I'm being forced in some way to submit to a vaccination, to a jab, I think that's an infringement of my liberty. I don't think that I should have to do this to get in or to gain entry. To me, this is a violation of my liberty, or even a violation of my life. For example, if what you're doing is putting something into me that I think is perhaps poisonous, for example. So this is an enormous section. So let's just over to you on Section 7, Carissima.
Yes, so there have been books written about Section 7. There are dozens and dozens, I venture to say hundreds of cases, court cases dealing with Section 7 in a variety of areas. I mean, Section 7 is in the part of the charter that deals, with what we call the legal rights. So it clearly has a profound importance in criminal law, but the courts have recognized that it can also extend beyond criminal law to other kinds of interaction with the state. So the first thing to recognize about Section 7, when I teach constitutional law or criminal law and I'm introducing students to Section 7, is you need to think about it as involving two stages. There's two steps, there's two parts to the Section 7 guarantee in the Charter. The first are the protected interests, which are life, liberty, and security of the person. That's each of those, and each of those has related jurisprudence, case law articulating what that means. So if we take the liberty interest, for example, it clearly would include restrictions on your liberty in the sense of sending you to prison. I mean, that's the most foundational interference that we commonly encounter in Section 7 cases, right? So criminal law, sending someone to jail. But what about other kinds of restrictions in the sense of the law is simply preventing you from doing something that you would like to do. So the law restricts you from entering a particular place, a public place. There's restrictions on your entry. And the liberty interest in that context, where the state is not literally locking you up, but other kinds of liberty interests, the way that the court tends to regard that is, does it conflict with a profound personal choice? So that Section 7 then doesn't cover everything you might wish to do in your daily life. That's not necessarily going to fall under the liberty interest in the Charter, but a profound personal choice. So choices around who you marry, choices around how you raise your children. And I would think absolutely choices around medical treatment would, I believe, fall under the liberty interest. So that's all well and good. That's the first stage. But the second stage that's really important is that Section 7 protects those interests in a particular way. You can't be deprived of those interests in a way that is, and this is right from the language of Section 7, that violates the principles of fundamental justice. That's how we can send people to jail and yet respect Section 7. We do so in a way that respects the principles of fundamental justice. We give them a fair trial. We allow them to have full answer in defense. They have the ability to have a lawyer represent them. Those are all things that comport with the principles of fundamental justice. Now, as I say, that's because Section 7 is frequently invoked in the criminal context. We're talking about proof of vaccination, which I would agree would invoke your liberty interest. The next step is, how is the regime, the policy structured? Is it in accordance with the principles of fundamental justice? Now, there isn't a neat and tidy place you can look to see all of these principles. They come to us from case law. But for example, the policy can't be arbitrary, right? It has to be guided by some kind of coherent rationale. The policy cannot be overbroad. That's a really important principle under Section 7. So it has to be reasonably tailored in terms of what it's trying to do. And the law cannot be, and this is a legal term of art in Section 7, grossly disproportionate, so that the effect on the individual is out of all proportion to what the law is trying to do. Those, I think, are the three primary principles of fundamental justice that might be at issue in a vaccine mandate. And I would have to say, given what we've heard about how these proof of vaccination regimes are being structured, I think it might be difficult under Section 7 to argue that the principles of fundamental justice are not complied with, but it would depend on the case. So, that's an arguable point, but looking at other kinds of similar charter challenges under Section 7, I think as long as the state has a reasonable basis for describing why it has designed a system the way it has, I tend to think that the principles of fundamental justice would probably be observed. So Section 7, I think, is a slightly tougher sell in terms of a charter claim than the fundamental freedoms.
Okay, now what about the right to life? Can you distinguish that, or can a person distinguish that from right to liberty?
Absolutely. So the right to life would be where the particular policy actually puts you in some peril of your health, or indeed even your life. The only place that would really come up is where a person would have an argument that taking the vaccine poses a true medical risk, which is something, as I understand it, is fairly rare, that in terms of what I've heard being discussed, but I'm not going to get into the medical back and forth around the vaccine, but it would have to show that the taking the vaccine would actually put you in some kind of physical peril. And in that case, yes, if the law did not grant some kind of medical exemption, or did not make allowances for people who cannot receive the vaccine for a valid medical reason, yes, that I think would pose difficulties under the principles of fundamental justice. But precisely for that reason, I'm not aware of any proposed regime or any existing regime that doesn't address the issue of medical exemptions. And I would just say that also can raise a question of disability, which arises under a separate section of the Charter, Section 15. But this is where we tend to have maybe some overlap between different rights in the Charter.
And which is why often when people file claims, they'll file under several sections.
Absolutely.
Exactly.
Yes. They want to get in all their kicks that they can.
Right. And of course, the court is still in the process and will be forever and a day interpreting these sections, and depending on the cases and depending on the facts and the context. Now,
and Pat, I also wanted to say, like in my conclusion, where I said it's likely that many of these vaccine certification regimes would be consistent with the principles of fundamental justice. I am talking about the case where proof of vaccination is required to access certain places. I'm not talking about a case where the state is simply ordering everyone to get vaccinated. So that I think would raise slightly different arguments under Section 7, but to my knowledge, no one in Canada is talking about that.
Okay, thanks for that clarification. And I just want to mention that someone in the Q&A has asked, could you please explain or clarify what counts as a state actor, such as when state powers perhaps are delegated to private entities?
So that's a great question. So it's a complicated question. I have like a whole lecture in constitutional law on this issue, but yes. So private entities like hospitals can be bound by the Charter when they are performing what is considered a government function. So the Supreme Court has held that when hospitals make decisions about how to allocate publicly funded healthcare, that's a government function. And in doing so, they must respect the Charter. For example, they can't discriminate, right, in how they structure their services. So in some instances, it's true you have non-government actors because they don't really have the status of government, but they're performing functions that are governmental in nature. There's a whole test around that. And I would just say that it's the group that falls under that umbrella is fairly small. There are also entities that are entrusted by the state to regulate certain professions, or where they are empowered by the state to exercise powers of coercion, where they can demand that people do certain things. That can also render those activities by that otherwise private actor subject to the charter? So it's a great question, and I'm happy to provide that clarification.
Thank you very much. Now, I have another question around Section 7, which is, and we won't deal with security of the person per se, but I wanted to ask you about positive rights. And I know that the Charter, by and large, is used to protect people from actions by the government, laws, regulations, policies, etc., that violate their rights and freedoms. But can the Charter be used to compel the government to do something that, for example, might protect your life, liberty, or security of the person? So do you think that someone could go to a court saying, I think the government needs to mandate vaccination against COVID-19, because without that mandatory vaccination, my life and liberty are compromised? This is serious.
Yeah, it's a great question. The more general question about positive obligations, so where you can use the Charter as a sword to compel the state to do something, as opposed to as a shield against state action. You're really trying to use the state to affect some policy. That has been a long-standing question under a few different rights in the Charter, including Section 7. The challenges have not been successful thus far. So the Supreme Court has not as yet recognized Section 7 extending in that way, with a couple of exceptions. One is that where the state has initiated some process that puts you in peril vis-a-vis one of your Section 7 rights. Best example of this is where the state has initiated a proceeding where it's going to be taking away your custody rights of your children, guardianship proceedings. There, it has been recognized that in order to render that process fair, the state may have to fund your lawyer if you do not have the funds to pay for it, and that's what's required to make the process a fair one. We can think of that in a sense as a positive obligation, but it only arises because the state has chosen to initiate some process. If you're talking about where you have a clean slate, a blank slate, and you want the state to actually step in, the case law under Section 7 does not go there as yet, and the courts have been concerned about that opening up an arena which would be quite difficult for the courts to adjudicate and sort of draw lines and make decisions that perhaps are better left to legislatures and other political actors. It's also important to note that healthcare itself is not a right under the Charter. So while, of course, we have a tradition in Canada of publicly funded healthcare, it's clearly a very important political and social interest. The bare provision of healthcare itself is not actually guaranteed under the Charter. When the state enters that arena, it's bound by the Charter. So it can't discriminate. It has to ensure that the provisions accord with other Charter rights. But the courts generally are quite cautious about weighing into that area. And I think that they would treat this in the same way. So I wouldn't be very optimistic about the chances of some kind of positive rights claim to have the state take more aggressive action vis-a-vis something like COVID-19.
Right. Thank you very much. It's a fraught question, I know. And it gets us into separation of powers. The courts don't want to be in a position where they're telling the legislature what it must do or spend money doing X or all of that. Yeah. Okay. Thank you for that answer. And all right, now we as a center, we've done a session on mobility rights and the pandemic, but I think it's probably important for us to talk about Section 6, mobility rights. And I thought it might be useful to just read the section out, because not everyone knows what this section actually says. So Section 6 of the Charter of Rights says, every citizen in Canada has the right to enter, remain in, and leave Canada. And 2, every citizen of Canada and every person who has the status of permanent resident of Canada has the right to move to and take up residence in any province and to pursue the gaining of a livelihood in any province. So people are asking, well, if you are going to restrict my ability to travel interprovincially the government, that is, if the government's going to restrict my ability to do that or to travel internationally because I'm not vaccinated, is that not a breach of my mobility rights?
It's a really good question. And, it's interesting in the last 40 years, the few times we've seen Section 6 invoked, either is with really Canadian citizens that encounter some kind of barrier when they're outside Canada trying to re-enter. So for example, the government, their passport lapses and the government refuses to issue one for whatever reason. Or people moving from one province to another and trying to seek entry into a regulated profession, like the law, like the practice of law. That's really where all the Section 6 case law has been, because of course we've never had this situation before. I'm certainly not since the charter was enacted in 1982. We've never had a situation where we've had multiple jurisdictions putting significant restrictions on interprovincial mobility. So in terms of the scope of Section 6, it clearly applies to Canadian citizens who have a right under Section 6 to enter and leave Canada. And we really, unlike some other countries, we never prevented citizens from returning, as some other countries have done, which I think is a very severe restriction on the mobility right. Interprovincially, it's interesting because the section of Section 6, it has a couple of sections that relates to that. It talks about being able to enter into a province for the purpose of establishing residence there or seeking a livelihood. It doesn't talk so much about incidental travel, but some lower court cases have viewed that as being inherently part of the Section 6 guarantee. I think there might be a question as to whether that might be more the liberty interest under Section 7, but regardless, I think that restrictions on interprovincial mobility, so being able to pass provincial boundaries, would certainly count under Section 6. The trickier question is the mobility right within a province. And there, I think you'd have a bit more work to do to try and make the argument that Section 6 does not even, is invoked even when you're not crossing any boundary at all. You're within entirely the confines of a province. And there I do think that probably the more fruitful route would be Section 7, or one of the other charter rights that we've been talking about.
Okay, thank you. All right, now there are other charter rights that we could talk about, and we could probably spend the rest of the session talking, for example, about equality rights, which protect people against discrimination on a number of enumerated grounds: sex, age, race, etc. And I think rather than go into Section 15, I think, given that I'm just looking at the time, let's move then to Section 1 of the Charter. And Section 1 is the section that allows the government to justify whether or not its laws, regulations, policies, etc. I'll read the section out specifically. The Canadian Charter of Rights and Freedoms, and this is Section 1 of the Charter, guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So people are expecting the government to demonstrably justify all these laws and restrictions that they're putting into place. So people are asking, how does a government do that? And how is a court going to decide whether the government's justification is good enough? And does being in a pandemic just suddenly somehow give you carte blanche to do whatever it is you want to do?
So let me start at the back end and work my way to the first of your questions. I don't believe the pandemic is a get out of charter free card. Absolutely not. I don't think the courts really approach it that way either, although there is no question that the pandemic is an exceptional circumstance that governments are reacting to, and that fact does affect the ultimate balancing. Section 1 is about a balance. It's the very first section in the charter. It actually, if you look at the actual wording, it guarantees the rights and freedoms in the charter, but it says those rights and freedoms are subject to reasonable limits, demonstrably justified in a free and democratic society, right? So it's really putting to the state, if someone is able to show an initial infringement. So if you think about how a charter case works, the person who brings the charter claim has to show my freedom of religion has been infringed. Then literally the burden shifts from the claimant to the government. The government is given the opportunity to prove, does have to prove, it has to demonstrate that it's a reasonable limit. So the pandemic, I think, is an important context, and it is true that because of a variety of factors in the pandemic, the fast-moving nature of it, the scale of it. I mean, you're talking about issues that affect the population as a whole. There aren't many exigent circumstances. If you think of a public, emergency like a forest fire or something, it tends to be quite regionally based. This is something that affects the population as a whole. That's why this is, a generational event. And where the government is receiving tons of information, there's lots of scientific data being produced. In that context, yes, will the courts be sensitive to that fact and be aware of their role vis-a-vis the government's role in sifting through that information? I think so. But the charter continues to apply. It's really important to stress that the charter does not cease to exist because we're in a pandemic. I think that another question you asked was, how do the courts do this? Well, the courts do what they've been doing for 40 years now with respect to the charter, which is that they receive arguments, they look to precedent in terms of the actual structure of Section 1 and how you weigh its various components, and they perform that function. I mean, that's the core function of our courts, is to uphold the Constitution, to be the guardian of the Constitution, to safeguard our rights and freedoms, but to also allow for that balance in certain circumstances, because the social benefit may require in certain contexts that rights and freedoms have to be infringed, and the law has to be upheld. Section 1 itself, there's a test that goes into it, and we can talk about that, but maybe I'll just stop there. And if you wanted to clarify any particular points, Pat, because otherwise we could literally talk for Section 1 for half an hour.
Easily. Well, I guess the big question that people often ask is, what part of the test that the court uses involves minimal impairment? The question is this restriction that the government has imposed, is it imposing it in the least restrictive or impairing way? So when you look at the charter right, either freedom of religion, freedom of conscience, freedom, right, liberty to security, right to life, liberty, security of the person, is this restriction that they've imposed the least impairing way? And I guess one of the questions I would have is, are these, for example, I'm just thinking about Alberta, they've just recently imposed the restriction exemptions program, and asked, or actually told restaurants that if they want to stay open, they have to monitor that people who enter are double vaccinated, as an example. So the question that might arise is there another way for the government to get to where it wants to get to other than to do that? And so is that minimally impairing? And so do you have any thoughts on that?
So minimal impairment are not actually words you'll find in Section 1. It comes out of the seminal, the first real case where the court grappled with Section 1, which is a criminal law case. Again, just to put that in context, it's a case called Oakes. Every law student in Canada knows that case well or has heard of that case. And the court said there are a number of steps in Section 1. Maybe we'll just briefly go through them, because it helps, I think, to consider minimal impairment within the larger framework of Section 1. So you have to show that the limit is connected to a legal rule. That's the actual language of Section 1. It's a bit technical. It's called prescribed by law. That's really important. Before you can violate your charter right, the state has to be authorized by law to do so, whether you can point to an actual statute or the statute authorizes state agents to do certain things. That's super important. Once you demonstrate that, the law or policy has to have a pressing and substantial objective. I don't think there'd be much argument here that laws taken to prevent the transmission of COVID in particular, especially indoor spaces where it's been proven to have risk, that's going to be pressing and substantial. But then whatever it is you're doing has to be rationally connected to that objective. So in this case, proof of vaccination. Again, I don't think that would be difficult for the state to show then it's at that point that you start to consider the actual effect of the limit on the rights holder, on the individual whose rights have been infringed. And the courts have used this language of minimal impairment. Now, there has been a lot of case law around what minimal impairment means. Does it, for example, mean they have to prove that it's the least restrictive regime they could possibly have chosen? Or do they have to show that they had a variety, they had some alternatives, and they picked the one that represents a reasonable choice in terms of what it is they're trying to achieve? That's it. And so that would be something the courts would be weighing and considering. Certainly, the government would probably be relying on public health advice that they have received. They might be relying on the evidence from other jurisdictions showing the effect once you actually have proof of vaccination in place. And the courts would engage in that balancing. And then it's important to note the final stage of Section 1, this is the final thing that the government would have to show in order to uphold the restriction, is what we call overall proportionality between the beneficial effects of the restriction and the negative effects on the person. So there's a final safeguard or check for the charter right, when the court looking at the picture as a whole. Is this restriction proportional? So to answer your question, I think as if the government is able to show that it considered some alternatives, and it was able to rely on some evidence, right, to show why it chose the regime that it did. I tend to think that minimal impairment in terms of proof of vaccination to enter certain places would favor the government. And this might be a case where we actually get to the final stage of Section 1. We look at the overall proportionality, right? What is the social benefit versus what is the individual harm?
Well, that is a fabulous description of how Section 1 works. Thank you very much. And the Oakes test in particular. Thank you. It's a complex test, and that was great. Now, so thank you for that. So I think what we'll do now, since we're at 10 to the hour, is we'll go to some of the audience questions, because there are several of them, and some of them pertain obviously to some of the points you've been making. And so one of the questions is, now a number of people have asked the question, can they be fired for not getting the COVID vaccine? And that's really not a question that we are going to be answering today, because it doesn't pertain specifically to the charter. That, you know, it's. But there are other questions here that do. One of them is, provinces are not making vaccinations mandatory for citizens, but they are for some workplaces, for example, nurses, all civil servants. Does that raise a Section 7 claim in your view? Is Alberta Health Services mandatory vaccination requirement for its employees unconstitutional? In other words, is it basically a state actor?
Yeah, so that's actually it's an interesting question, because the employment relations within certainly within hospitals, you know, that's still a gray area. I think if it's an actual government department or government, I'm not, you know, entirely sure of how it works so if it can be considered part of the Alberta government, then it would be bound by the charter. I will just say that when you're talking about mandatory vaccines, it's still vaccines become a condition of doing something, retaining a certain status, gaining access to a particular place. So it's still, I don't believe it would be considered mandatory vaccination in the sense that I've been talking about, where the state just requires everyone to get vaccinated. It's still a condition to either continue in a certain position or to gain access. And therefore, there I think we would have the same charter analysis that we've been talking about. But the fact that it is in relation to health services, for example, might affect the argument that the government would make at the Section 1 stage.
Right, thank you. And a question I'm just going to quickly answer is, was the second part of the Section 7 analysis referring to the Oakes test? And just quickly, no, it isn't.
No, it isn't.
The second part of this of the section of Section 7 is its own section.
It's its own thing. Yeah, this is where it gets it. And this is why it's also important. It might be just helpful to make this point. The charter rights themselves are very distinctive and different from each other. And they eat because they have their own language, they have their own tradition and heritage in terms of what we look to, what was the purpose of those provisions, and they have their own very detailed, established, decades-long case law associated with them. So it is important to note that each charter right has its own legacy of case law and argument that is quite distinctive in and of itself vis-a-vis other charter rights. And then on top of everything, you have Section 1.
Right. And so the Oakes test only pertains to Section 1, just to be really, really clear about that, even though they sound similar.
That's right.
Okay, now let's get to another question. Now, I don't know if this one is, I'll read it out, see if you can answer it. Freedom of conscience and the sincerely held belief. Do you think that a belief that is counter to current scientific consensus would be given less weight by a court?
So that's a really great question that would go to how we delineate freedom of conscience versus, for example, freedom of religion, where the idea of applying a scientific or rational kind of scrutiny to that would clearly, arguably undermine the entire point of faith and faith-based beliefs. I tend to think not, because it would really be tied to, does the individual sincerely believe that they are being forced to violate a really profound personal view or dictate that they hold? That said, that question would, I think, absolutely come into play at the Section 1 justification stage, because it would go to what is the effect of this belief on some broader social goal. If we simply allow if the person is essentially saying, I have to be accommodated in this belief to the fullest extent possible, even in the context of a serious pandemic with mutating strains of the virus that pose grave risk of transmission, disease, and death. So I think that's where it would come in, but it really wouldn't be about the belief so much itself as it would be about what is the effect of giving space for the person to hold that belief and then not follow the rule. Right? It's not following the rule that's being enacted at a population level to protect the health and safety of the population.
Okay, thank you. Oh, now another question here. Are there examples you know of where the state has moved in such a heavy-handed way and then backed off after the need for state interference has passed? And the person who's asking this says, many folks are saying that once the state moves into this space on our health, there will be no more, and I don't know, the word is invasions, but she may mean invasion. So, and she refers to the Texas case on abortion and the decision there around that, and how the state has changed in that regard.
So maybe we'll put the Texas abortion case, really interesting Texas abortion case, to the side, unless, and if there's clarification, we can answer that. I think this is a very fair concern, right? And we have our history, for example, with our concerns around terrorism after 9/11. In the moment, extremely urgent concerns that have been sporadic, that have arisen sporadically since 9/11, but have created an enormous state apparatus around national security and involving surveillance and oversight and privacy breaches and provisions taken around air travel that we still follow, even though, frankly, the security reason for the liquids ban or the liquids limit has I believe been shown to be less strong, but we still do it, right? So I think that's a very fair concern. What I would say is that when the court rules on a particular regime around, let's say, proof of vaccination, the Section 1 argument has to relate to the facts and the situation at that time, and particularly where the government is reacting to a present threat. As that threat recedes, for example, at some point, someday, the COVID pandemic will end. I mean, we know this from past experience. It may become endemic, but the pandemic will end, like the situation will change. And if those restrictions are just maintained in place, I think there would be a very good basis to challenge that, assuming that the government was not already motivated to get rid of it. So unlike, for example, the national security concern, I'm not convinced that the governments will see a lot of upside in maintaining these restrictions in place indefinitely, because they do arouse very strenuous opposition.
And so evolving is the term. Really.
Yeah, but it's a fair concern, and some of the precedent we have is not great. Like it doesn't give us a lot of comfort, but I do think that there are enough distinctions in the areas, and especially as well, you're talking about these restrictions that are operating at a population level, affecting so many people. I do think there will be different concerns that motivate governments to be a little more responsive to the evolving facts on the ground, as we hopefully move through the worst of the pandemic and start to come out of it.
So it is possible then that a government could justify some restriction, in March of 2020, and not be able to use that same justification now because of what's evolved, because of what we now know, etc. So,
I agree. And I agree, for example, as the rate of vaccination has increased, I would be more skeptical that a province would be able to simply, and the epidemiology changes, I think provinces would be in a different position were they to try and keep people out, other Canadians out of that province today than they were in March of 2020. So the mobility rights, I think, would have a different context as well.
Right, exactly, especially mobility rights. Now, there's an interesting question here about elections. Elections Canada has said people who refuse to wear a mask or are not vaccinated may not be allowed to vote in person. Does this infringe Section 3 of the Charter? And Section 3 is, by the way, just to read it out, every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly and to be qualified for membership therein.
Yeah, it's a good question. I mean, clearly the right to vote is supported by an entire substructure with and its own law, right? The Election Act, the Elections Act, that has conditions. Like there are conditions in terms of proof of identity and so forth. So I don't know that in itself would count as a violation of Section 3 if there were other methods provided. In the event that the person says, look, the communication was not great, and I missed the chance to vote in person, and I went to the returning office and I wasn't allowed to vote. In the event that was accepted as an initial, or the legal term is prima facie violation of Section 3, I think that there would probably be a good argument under Section 1. But it's true that in terms of publicizing that rule, there should be a whole alternative method offered to people who don't wish to wear a mask, because the right to vote is really important. And so that would be part of the mix in terms of analyzing whether the charter right to vote, the democratic right, has been respected.
Okay, thank you. That's I think it's because it's so imminent. It's an important question to ask and answer. Now, what is your view about the position that post-secondary institutions perform? Is it a government function? And does the charter apply?
Yeah, so this is interesting. So in an early case involving the University of Guelph, a case from the 1980s, the Supreme Court held that universities are not government actors. And they relied on the special role of universities, and in particular, the fact that universities are supposed to be places where government policy is freely and fairly challenged. And so even though universities receive public funding, which is the threshold in the United States, for example, whether you have to abide by the Bill of Rights, in Canada, the test is a bit stricter. And so the Supreme Court, as yet, has not recognized universities as government actors. There have been some lower court cases. That was a case that involved mandatory retirement for faculty. Okay, so that was the rule that was being challenged in that case. In more recent cases, including some cases in Alberta, involving student discipline, where students were being disciplined for things they said on social media, some Alberta courts have held that, in fact, in that context, the universities are acting as government actors, and they had to adequately balance the students' freedom of expression. So that's a live issue. I tend to support the initial analysis of the Supreme Court in that 1987 or 88 case called McKinney and the University of Guelph. I don't think that universities should be considered state actors. They are, of course, bound by human rights codes, just like a lot of other entities. But we'll see. We'll see if a case on that issue eventually reaches the Supreme Court. Will it sustain that early ruling under the charter, or could it reach another result? Perhaps, again, based on what it is exactly that the university is doing. I doubt that the Supreme Court would say that in all of its functions, the university can be considered a state actor, but perhaps in some of its functions.
Right, and it's too bad we don't have time in today's talk to describe how human rights law works, because of course there are protections in place for people using human rights law that are effective. But it's another area of the law, and it's not specifically the Constitution. It's called quasi-constitutional legislation. All right, so I'm going to go to another question here, which is about the speed of court cases. I'm concerned about the slow process of court cases, particularly when things change so quickly with new restrictions or rules every week. How can this be challenged in court in an expedited fashion? How can we hold our government to account? It seems likely that many of these challenges will not be heard for years from now.
It's a very fair concern. The pace of justice is slow, probably too slow, and it's only fair to realize that it's been exacerbated to a tremendous degree by COVID itself. The backlogs just in, criminal law, in family law, in civil law is tremendous. And if I can just deviate slightly, I think this is something that we really need to be thinking about in allocating the resources so that access to justice, both criminal and non-criminal, is sustained, because we are right now, we are under a huge mountain, a huge burden, in part because of COVID, and because before COVID, the situation wasn't that great either. So it's a very fair question. What we see in the majority of these cases is you can ask for an injunction. So that's something that you can go to a trial level court and ask for the whatever policy it is to be enjoined if you can surmount a particular legal test. And the test is not an easy one, but that is a way to get relief earlier than having to go through the entire course of either a trial or whatever procedure it is that you take, and having to adduce all that proof and have the court rule. Even just at the trial level, that can take many months, and it could take even longer because of the pandemic. So I think it's a very, very fair concern, and there isn't, unfortunately, an easy answer to that dilemma.
Yes, access to justice has been something on people's minds for many years, and the wheels just don't seem to be working a whole lot more quickly. Now, here's a question involving Section 15, which we didn't get into, but I thought it might be useful to ask. Sure. I know you didn't address Section 15, but if time permits, if exemptions from proof of vaccination are not carved out for persons with medical contraindications, do you think that would be discriminatory on the basis of disability? And I'll just include, even though this person hasn't mentioned it, but there are other grounds: disability, age, race, etc. The person then asks, what about a Section 1 analysis on that issue?
Yeah, it's a great question. So I do think that if so first of all, I do think that medical barriers to receiving the vaccine in this context would probably fit under disability. If it didn't fit under disability, it would probably fit under security of the person or even life under Section 7. But let's just stipulate that it fits under disability. And then being prevented from accessing that would seem to be you're preventing people from accessing a benefit that's available to other people because of a characteristic that over which they don't really have control. They can't change that characteristic. Now, the only point I would make here is that the exemptions in the policy might not require the state to offer that unvaccinated person who has a medical reason access to the space in which the transmission risk is high, right? And depending on the context, it might be that they would have an alternate way to receive that service, because the state might be able to argue, well, but we still have the underlying concern, which is the risk of transmission. So that might potentially go into whether we would ultimately determine it's discriminatory under Section 15. It might also come up under Section 1. Section 15 is another one of those really loaded, and by that I just mean there's a lot of elements to it, like Section 7. It's very different, but it has a lot of moving parts, if you will. So the actual analysis of a discrimination claim where the issue is the contours of the medical exemption and how the state chooses to deal with that, there could still be, some live issues. But certainly if the state just, treated it as a blanket policy and clearly hadn't even thought about people who have medical reasons, I think that would present a fair concern under Section 15. Yes.
Great, thank you. Now, this is an interesting question, I think, in part because you have a background to some extent in criminal law as well, some expertise. And the question is, criminal trials are held to a standard of beyond a reasonable doubt. Mm-hmm. Could vaccines hold this standard, given that the science is always evolving? I think what the person means is, could the government be held to that standard?
It's a great question. So this is a question, we call it the standard of proof in litigation. We talked about the burden of proof. So the person bringing the charter claim has to demonstrate the initial infringement, and then that burden literally shifts to the state that has to make out the Section 1 argument. But what's the standard? Like, to what degree does the judge have to be satisfied of the arguments? So criminal law is the only legal area where we have this extremely high standard of proof, which is proof beyond a reasonable doubt. It is unique to criminal law. The standard in charter litigation is generally considered to be a civil standard. It's the preponderance of the evidence. So on a balance of probabilities, either the claimant would have to demonstrate the infringement of their charter right, or the state. So the standard of proof is the same at all stages of the charter argument, and it is not to that criminal standard, and it will not be, and it's uniform for any constitutional case. It doesn't change depending on the subject matter. So it would not be different in a case involving vaccinations or some kind of other state decision taken under the pandemic.
Okay, thank you. Now, this is it's a straightforward question, but I think it would be useful to answer because there are a few questions along this line being asked. If a vaccine passport were found to be unconstitutional, what section would you expect it to fall under?
Well, it's difficult to answer that in the abstract, because it would have to be, well, what are the contours of the proof of vaccination regime? So, would it be one where there were simply no alternatives to receiving the service? Is it one involving a service that maybe straddles the line between essential and non-essential? I just wanted to point out that, of course, as far as I know, none of the certification regimes we've heard of would restrict unvaccinated people from having access to hospitals, to get essential goods and things. It's around other things that, of course, we've all missed so much during COVID. But I think there could be some arguments around the disability, perhaps, aspect. Like, are we? Is it inconsistent with the charter to say that people who cannot get vaccinated just simply can't access certain things for a while? Is that too high a burden on people? Because we are very concerned about ensuring that as a society we treat people with those kinds of medical conditions fairly. And that would be the only one I can think of without more context as to what the regime says. I have to say that I think where you're talking about proof of vaccination and not simply requiring everyone to get a shot, period, I think the charter argument is not going to be that easy to make out, depending on what it is you're being denied access to. I'm not saying that it can't be made out, but the courts will be sensitive to the underlying problem that we're facing as a society, I think.
And so this person is clarifying here, and they're really asking the question. You've talked specifically about the fact that you're not talking about mandating vaccines for everyone, but rather describing conditions under which you can do certain things. So, but this person's asking, if the government did create a regime or mandated that everyone in the province had to be vaccinated, would that be unconstitutional under Section 7?
Yes, I think that, I think it would raise a stronger claim. I do think it would raise a stronger claim, particularly what were the consequences. The government would want to think very carefully before it simply, enacted a rule that everyone had to be vaccinated. Now, if things change, right, so that vaccination really becomes critical, then to a more of a degree than it is now, that could change the calculus. And I just would say that similar regimes have been upheld in other countries with similar constitutional guarantees. Remember, it comes down to those principles of fundamental justice, right? Is the law arbitrary? If it applies to everyone, it's clearly not arbitrary. Is it overbroad? Well, there the government will have to show why it is taking this extraordinary step. And it would be an extraordinary step in Canadian law and politics. And then finally, the gross disproportionality. There, I think the government would clearly have to have exemptions for people who, for safety reasons, cannot receive the vaccine. But again, I would just tend to think that the circumstances in which the government would put in such an extreme measure would have to be themselves extreme. And that would, I think, potentially affect the calculus under Section 7. But yes, a state-ordered vaccination for all would raise different concerns under these rights.
Right. Now, here's just on a different note, but again, Section 7, not surprising. Entering certain places may be part of earning a livelihood. Does the right to earn a livelihood fall under Section 7?
Great question. And the short answer is it does not. It does not. So if you think about the protected interests under Section 7, life, liberty, and security of the person don't have reference to a property interest, as you do, for example, in the Fifth Amendment to the U.S. Bill of Rights. And the courts have noted that the lack of a specific property right anywhere in the charter, other than the mobility right we talked about, where you have the right to move to another province for the purpose of taking up a livelihood. But we'll put that to the side because we're not talking about that here. So the courts have noted the absence of that language and to say there is no Section 7 right to earn a particular livelihood. You have the right not to be discriminated against in ways that could affect your ability to earn your livelihood. But Section 7 itself does not protect the right to work to hold a particular position.
And I'm wondering if the person actually was wanting to say, if, for example, I was working for Alberta Health Services, I'm a nurse, and I just don't want to take the vaccine. but I'm being told that I absolutely have to. So doesn't that somehow compromise my ability to earn my livelihood? How would you respond to that? And I think a number of people are asking this question.
I think it does have it clearly does have a profound effect on someone if this is something they really feel strongly that they don't want to do and it becomes a condition of work. The issue is that your initial ability to pursue that occupation is not protected under Section 7. So that's not to say it wouldn't be a profound effect on you. It's that Section 7 would not have much to say about that effect, as serious as it is for the individual.
There might be other laws, but we're not looking at a section of the charter.
There might be other laws for sure, absolutely. And if you could show that the belief is linked to your religion, you could argue that you're being deprived of that position because of your religion. And if the entity is a government entity, yes, that would be a violation of freedom of religion. Then you'd get into Section 1.
Right. Okay, now there are a number of questions coming up that are somewhat similar. So I think you've addressed these, but I'm just going to ask them again because it's apparent that perhaps people still have these questions. And one of them is, and I'm just going to run two together here. If a person is forced to take a vaccine and they have a reverse health reaction or even die, who takes responsibility for that? And then another person is saying, on the opposite side of the spectrum, what about those who believe there will be an adverse reaction or the vaccine is harmful or unproven? Do vaccine proof requirements raise security of the person issues? Is there room to argue that requiring proof of vaccine to access publicly funded education or to work in a public sector job invades a person's bodily integrity, subjects them to risks of adverse vaccine reactions, and thus implicates security of the person?
So the security of the person interest is understood under Section 7 as subjecting the person to a particularly high level of stress caused by the state, forcing them into making a really difficult choice. So the security of the person is understood as more the profound effect on your mental well-being, because the state in effect puts you in almost like an impossible position. And I know that for some people this may seem to be that, but the courts have been fairly cautious or restrictive in how they determine whether the security of the person is actually on the table. And it would be relevant here, at least given the case law we have so far, that again, the right to seek a particular occupation is not protected under the charter. This has come up where people are, facing some kind of medical procedure, and it came up, for example, in the context of the medical aid in dying legislation, where you were being prohibited by law from seeking medical aid in dying, and your security of the person was engaged because in that context you were under significant stress. So the security of the person argument is certainly open to be made. It would be affected by the fact that the court has said that earning one's livelihood is not protected under Section 7. So I think there could be some difficulty there. In terms of beliefs about the vaccine, that's interesting. Under Section 7, or certainly the beliefs, there would be some point at which, whether it is under the actual charter right or under Section 1, not all beliefs are going to be treated equal for the purpose of determining the contours of a proof of vaccination regime. People have, I know there's a lot of different views about this, but it wouldn't be subject to that scrutiny if it's under, freedom of conscience or religion. But if you're trying to argue that there's a particular risk to vaccination per se, as opposed to you have a strong belief against taking the vaccine, that would be a more difficult argument to make under the charter rights as we currently understand them. Then you're actually just getting into a debate with the government about what the proper policy is, and it's not affecting your rights to the same extent. So obviously people are, lots of people feel this is a really important choice, and they have views that may not accord with the government in terms of the actual science. The charter doesn't necessarily protect those views or hold those views on the same level as, the government putting to the court particular evidence to support its view. It's a tricky area, but I think it's important to note that not all beliefs are going to be treated the same. Not all evidence is going to be treated the same in a charter case, in an actual litigated case. And as for the risk that the risk of harm, that would be it would be dealt with as a separate issue in terms of what is the duty of the state to compensate you.
Yeah, and actually this is all a positive statement in respect of how our courts work, because they do take the context into consideration, the facts, the circumstances, etc. So when people get frustrated, when professors will say, for example, well, it's contextual, everything is contextual, but in fact, it's important that it's contextual. It's important that the court takes into account the section, what's required in that particular section, etc. Now, I'm going to ask a question here that is related. Can you speak to the importance of scientific evidence in the context of a Section 1 justification argument?
Absolutely. So but in a case like this, where you are balancing different interests, the government will be relying on public health evidence of epidemiologists, evidence of virologists, evidence from other jurisdictions, the progression of the disease, what we've seen in terms of case rates, hospitalizations, deaths. And the court will look for that evidence, but the court will not, I think, allow a lot of unsupported arguments around, let's say, vaccines, arguments that maybe are more tenuous or frankly might be based in disinformation. As I say, that's why I say it's really important that not all arguments, not all beliefs about what's going on in COVID are necessarily going to be admissible in court. There could be competing medical evidence that is presented to the court. Absolutely. You could have a doctor who's offside, who's not of the same view, and you introduce their affidavit. And then courts are very used to weighing that kind of conflicting information. But in this case, and this is important to say, the courts will tend to give the government some leeway and some latitude and some we call it deference in terms of the choices that it's having to make. And in this case, I think it is fair to say that there is a lot of evidence for the governments to draw upon. And there is a lot of scientific evidence that it will be able to point to, not to answer every single question. It continues to evolve. I think we've all seen that over the course of the pandemic. But this is where the courts will be careful about what is their role versus what is the role of the state when you are making public policy decisions to preserve health. Versus, of course, the very important rights that are protected under the charter. And let's just remember that, of course, ensuring the health of the population at large is sort of foundational to respecting everyone's charter rights. Like sort of ensuring that base level of security and safety is, of course, a precondition. It's so basically sometimes we don't even necessarily talk about it. It's a precondition to the kind of society where we can have the liberty that we so cherish, and the freedom to choose and the autonomy that COVID has really put an enormous damper on. So those are things too that I think will come into this kind of litigation.
Well, thank you, and that's perhaps the best way to end this presentation, actually, Carissima, because you've given us sort of the overwhelming and overarching way in which courts will take a look at these issues. I really want to thank you for giving us what it could be called a whirlwind tour of the Charter of Rights and Freedoms in respect to vaccine, the vaccine restrictions and what governments are doing right now with respect to vaccine.
You've gotten a 3-month course in 90 minutes.
Yeah, exactly. So I know that it's a very busy time for you, and I would just want to tell you how much we appreciate this, and also the care and attention you took to answer every single question that we had time to answer. And I know we didn't actually get, now excuse me for a minute, I was going to say we didn't get to every question. Okay, it's just if you can answer one more question. I'm getting a little nudge here. If someone becomes ill due to a vaccine, who is liable?
That's not, I mean, it depends on the jurisdiction. So I believe there was some debate in the early days about vaccine indemnity programs. And I think Canada perhaps is a bit behind the 8 ball, if I'm correct in remembering. So this is something where there's probably more work to do. Now you do, you do sign certain forms, but again, this is sort of getting out of the area that we're talking about today. And I would, you'd have to sort of refer to the various statutes and the various regimens that are in place.
Yeah, thank you. It's not a question that can be answered when it comes to the Charter of Rights and Freedoms and the Constitution. So there are so many laws out there, but thank you for answering the question, because it's come up a few times here, and that's why it was a bit of a nudge. Anyway,
I think it is fair to say that you wouldn't be without any remedy. I think it's fair to say that. It's just a question of who. I'm not in a position to answer that.
And actually, someone else asked a question regarding, at what point is something considered unconstitutional? Which section of the Charter? If I can remember this question. And I think what we want to say is that if the government is found not to have been able to justify the breach of freedom, that law will be found unconstitutional. It doesn't matter what section of the Charter it is. If they we're just at the end, but just there is then the final stage of a charter claim, which is the remedy stage. What is the court going to do? Will it strike down the law? Will it strike down just a provision of the law? Will it direct the government to go back and try again? Right? There are different remedies that can be taken, and there would certainly be argument about that in court as well. Right. Okay. Thank you. This really was the 3-month course in an hour and a half. Thank you. All right, so I want to also thank Zara Ahmed, our administrator, and Alina Rietsma, our public legal education coordinator, for the work that they've done in preparing and advertising this webinar. I want to remind participants that there will be a recording available on our website in the next couple of days, and also to thank you very much, those who participated. We had some 300 participants at one point, which is wonderful, but thank you for your engagement and your interesting questions. I mean, this is a very fraught time that we're in. There will be, again, a little questionnaire sent to you after this webinar, and we would appreciate your feedback. It's always useful to us. So yes, that's it. I just want to thank you again, Carissima, and wish everyone a wonderful rest of the day and weekend. Thank you.
It's my pleasure. Thanks, everybody.